can see. Great, Ken. Well, I'd like to thank you all very much for joining today. This is an OxFirst webinar addressing damage calculations in the United States. I have the great pleasure today of welcoming two extremely distinct speakers, and I could hardly think of anyone more qualified than our speakers today to talk about the question of damage calculations in US patent law. We have Judge Randall Rader here with us today and Professor Tom Cotter. Judge Rader has actually decided upon quite a few of the cases that we'll be talking about, and will be firsthand able to comment if our interpretation, understanding of damage calculation is actually what he had in mind in the first instance. And Professor Cotter is extremely well published in the area of damage calculations and the economics of legal remedies in international comparison. And I must say, I'm also a personal fan of both of our speakers. I think they had a very important contribution to the field of intellectual property and continue to have. For those who do not know OxFirst, OxFirst has been now up for 11 years. It started out of research within the University of Oxford on the economics of patents and copyright and trademarks. And we were a few academics at the time who thought that our research has meaning, should be having meaning in practice. And we started a company that does economic analysis around intellectual property mainly. And we have testified in cases on damages, and we continue to give our distinguished opinion on the economic value of licensing rates, and we help develop policy formulation by offering economic opinions on certain patent questions or copyright questions. And we also run a conference where I would like to welcome you very warmly, which is happening end of June in Munich. Our 7th Intellectual Property and Competition Forum, where we will discuss the licensing of standard essential patents and the upcoming policy discussions around that, and the policy consultations in the United States, in Japan, the European Union, the United Kingdom. Basically, this is starting to spread around the world, and we would be extremely happy if you were to join us. We very much hope we can meet in person. Possibly we'll run it also as a hybrid event. If you have an interest, it's June 22 and 23 in Munich in the House of Literature. We'll be sponsoring contemporary arts with that conference also. With all of that being said, and because I know Judge Rader will have to leave us sooner than I thought, I'd like to pass the floor on to Professor Cotter and to make you the presenter of, not share the screen, but how do I make you the presenter?
May I just say a quick word, Roya? I'd like to say that Professor Cotter is one of my heroes as well. I've consulted his writings on numerous occasions, including when I was on the bench. So we are honored to have him speaking today. I broke my clavicle yesterday in a bicycle accident, so I do need to leave earlier than I expected, but I will be here for the first 15 or 20 minutes, and I'm looking forward to Professor Cotter's excellent presentation. Thank you.
Thank you very much. There we go. All right, so what I will be doing over the course of the next hour is focusing on the principal topics under US patent damages law. I will probably only have time to get to the first 3 in any depth: lost profits, reasonable royalties, and extraterritorial damages, which is a topic taken up by the US Supreme Court in a fairly recent case. If I have a little bit of time towards the end, I will try to touch upon some hot topics relating to enhanced damages and awards of the infringer's profits for design patent infringement. These also are the subjects of some fairly recent Supreme Court case law in the United States. So I will have to be a little bit selective in deciding what to discuss. Given our limited time, I'm going to focus principally on the big principles, the key principles, and then a few hot topics. And I'm happy to take any questions or comments as they arise. So the principal statutory provisions that I'll be addressing under US law are the following ones. Most important, Section 284 of the United States Patent Act, stating that upon finding for the claimant, the court shall award the claimant damages adequate for the infringement, but in no event less than a reasonable royalty for the use made of the invention by the infringer. And that last sentence, the court may increase damages up to 3 times the amount found or assessed. Section 289, if I have time to talk about that at the end, is the provision that permits awards of the infringer's profits, but only in design patent cases in the United States, not in utility patent litigation. So starting with lost profits, it's important to realize up front that conceptually lost profits are the appropriate remedy when the patentee and the infringer compete in the same market, and but for the infringement, the patentee would have excluded the infringer from making, using, or selling the invention rather than licensing its use. So in other words, the patentee is entitled to recover the profit it would have made on additional sales that it would have made, absent the infringement. Less commonly, but another possible subcomponent of a lost profits award is an award for so-called price erosion. So if during the period of infringement, the patentee, in order to try to maintain its market share, reduced its price below what it otherwise would have been, then the patentee may be entitled to damages to make up for that component of the lost profits award as well. But either way, the principle at issue is to restore the patentee to the position that the patentee would have occupied but for the infringement. And all of that seems pretty straightforward, but it can result in some sometimes counterintuitive applications. So in terms of
Could I add one thing here,
go ahead.
Professor Cotter? This means you have to prove you would have made the sales of the infringer. And that's often difficult to prove, as I think Professor Cotter is going to go on to discuss. But one observation is that the area this tends to apply most is in pharmaceutical cases, where there's often only one patent and one market. And so that often opens itself up to easier proof that you would have made the infringer's sales. Excuse me for interrupting there,
No,
Professor.
please,
You're going great.
And I certainly agree with you on that. I mean, lost profits empirically are a minority of patent damages cases in the US for precisely the reasons that Judge Rader has indicated. It is often very difficult to prove them to the satisfaction of a court. These factors that were articulated in this 1978 decision, Panduit versus Stalin, are usually mentioned in the course of a lost profits opinion. Courts and litigants will often make use of these 4 factors. Specifically, the doctrine is that the plaintiff has to prove demand for the patented product. That's usually not too difficult. Secondly, absence of acceptable non-infringing substitutes. 3, that the plaintiff has the capacity to exploit the demand, and then the amount that they would have made. So I'm going to focus in our limited time on factor number 2, absence of non-infringing alternatives. So the requirement that the patentee be able to prove non-infringing alternative, or excuse me, let me rephrase that. The non-infringing alternatives have been relevant to calculating monetary awards in the United States for well over a century. And so the law in the US on this point is different from what I understand it to be, for example, in the United Kingdom. And the basic logic here of considering non-infringing alternatives, really 2 parts to it, or 2 different ways of thinking about it. First of all, if the defendant could have avoided infringement by employing a non-infringing alternative to the patented technology. And if the patentee, if the defendant would have made some or all of the sales it actually made using the patented technology, then the infringement did not cause the patentee to lose those sales. So this would have happened anyway, even if the defendant had not infringed. And then a slightly different way of thinking about it from a more economic perspective is that the economic value of a technology is the value the technology confers upon the user in excess of what the infringer would have earned using the next best available non-infringing alternative. That is the economic value of the technology. And so for both of these reasons, ignoring non-infringing alternatives would place the patentee in a better position than the patentee would have occupied but for the infringement, and would risk overcompensating the patentee for its contribution to the state of the art. And so briefly, I want to use the grain processing versus American maize products decision as an example. So in grain processing, the defendant infringed the plaintiff's patent for producing Lodex 10, a food additive. I believe the technical, it's maltodextrin. And so the evidence showed that the defendant could have produced a non-infringing product, Lodex 10, made by means of an unpatented process, and that consumers would have found this no different in quality than Lodex 10 made by means of the patented process. The evidence also showed that in this case, the defendant's profit margin on sales of Lodex 10 was sufficiently high that it could have used the unpatented process without raising the price that it charged consumers. And so it would have made the same number of sales, even if it had avoided infringing. So on that logic, the district court in this case rejected the plaintiff's claim for lost profits and awarded a 3% royalty, reflecting a portion of the value to the defendant of using the less costly patented process. And so the Federal Circuit, in an opinion by Judge Rader, affirmed that decision.
Could I make one observation here, Professor Cotter?
Please.
The important thing about this case was that the alternative was not even on the market at the time. It was a known alternative, and the defendant could have shifted to it quite easily, but it was not even on the market. The key finding here is that it could easily shift. In a later case, someone made the same argument, and it was shown it would take them 6 months to a year to switch to the new alternative, and that was not considered a non-infringing alternative. Excuse me for interrupting. I just thought I'd add those little points.
That is an important observation on this case. In some ways, this is an unusual case because the alternative was readily available, even though it was not actually on the market. And often the facts will be different, that the proposed non-infringing alternative is not on the market, is not readily available. And anyway, often the disputes will hinge on how readily available the proposed alternative is. Another implication of this but-for principle arises in a case, Federal Circuit decision from the mid-1990s called Reitheit versus Kelly. And so this case involved a patent owner that was selling two types of vehicle restraints. One was called the MDL 55, the other was the ADL 100, and one of the two embodied the 847 patent. The other restraint was said to embody other patented technologies owned by Reitheit, but the 847 was the only patent in suit. And so the defendant Kelly Corporation produced a competing product that infringed the 847 patent and was found to deprive the plaintiff of sales of both the MDL 55 and the ADL 100. And so the district court in this case awarded Reitheit its lost profit on lost sales of both products, meaning the lost profits on lost sales of the ADL 100, which did not incorporate the patent in suit. The Federal Circuit in this case affirmed, and I think that was the correct decision, although it has been a matter of dispute for the last 25 years. But I think this is the correct decision under the application of the but-for principle, because the patent owner would have earned additional sales of the ADL 100 absent the infringement of the 847 patent, and therefore was entitled to recover its lost profits on those lost sales, even though the ADL 100 did not incorporate the patent in suit.
This
And
is the famous case on convoyed sales.
That's true, and that is another aspect of it. So the Reitheid also sought lost profits on sales of collateral products that were, I forget exactly what the collateral product was, but something that would be used in conjunction with the vehicle restraints. And the Federal Circuit modified the but-for principle slightly under those circumstances and stated that the patent owner could recover lost profits on lost sales of these convoyed or collateral products, complementary goods, but only if they functioned with the patented product, if they, in some sense, formed a functional unit. If, on the other hand, as in this case, the convoyed products were only sold as a matter of business convenience, then the patent owner could not recover the lost profits on those lost sales. So that is
I think
something
that's
of a limit.
different than UK law. I think UK law, which is the more correct, would allow the convoyed sales only if they were reasonably foreseeable as a consequence, having nothing to do with the functional application. So I prefer UK law on this convoyed sales area, Professor.
Yes, and I agree with you on that. I do think that the UK law is more rational on that point. The Federal Circuit's limitation on the but-for principle as it relates to convoyed goods, I think, is difficult to reconcile with the general but-for principle and with normal principles of proximate causation. I'll mention one more implication of the but-for principle, and then I want to move on to reasonable royalties, and it's this. So suppose that the patent reads on a component of an end product that embodies multiple other features, and the plaintiff makes, uses, or sells end products incorporating the patented component. The defendant also makes, uses, or sells end products incorporating without authorization the patented component, and the patent owner can prove that but for the infringement, the patent owner would have sold X more units of the end product. So the question is, can the patent owner recover lost profits on those X sales, or should it recover only an allocable portion of its lost profits on the theory that to recover the entire lost profit would result in overcompensation? Does there have to be some sort of apportionment of the lost profits to take into account the fact that the patent only reads on one single component of this multi-component end product? And that is essentially what was at issue in this Federal Circuit case from 2017, Mentor Graphics versus EVE USA, where the court held that the apportionment principle is actually built into the Panduit factors. And so in a case like this hypothetical case, which reflects the facts of Mentor Graphics, what that means is that the court should estimate how many consumers purchased from the defendant, but would have purchased from the plaintiff but for the infringement, and then award the plaintiff its lost profit on those lost sales and a reasonable royalty on the rest. And so there really is no need to apportion the lost profit award, even though the patented feature is just a component of the relevant end products. This may be a fairly unusual situation as well. It's not going to happen all the time. Often consumers would have continued purchasing from the defendant, even if the defendant had used a different component. But if the evidence shows that the patent owner did lose sales, some number of sales as a result of the infringement, again, the general but-for principle, which I believe the Federal Circuit correctly applied in this case, would lead to an award of lost profits on those lost sales. All right, let me move on and talk about reasonable royalties, which are the more common type of monetary award in the United States. Go ahead.
Can I ask you both something? I have two questions. The first is, I had two questions. The first is, what happens if the parties to the case are not operating in the same markets, so that there wouldn't be a clear logic that there was a lost profit? Or what if the patents were from a patent assertion entity and it wasn't using these patents anyway to sell products? How would you go along in these two questions then?
Maybe I could take a shot at that first, Thomas, and you can correct me. The but-for test would require the same market. And the case that comes to mind is a case involving surfboards, windsurfing boards.
Oh, yes.
And it's the BIC case, B-I-C case, where there are two different kinds of boards with very different prices, and therefore they were in a different market. And the patent owner could not recover on the more expensive, different products because they were in a different market, and they would be impossible to prove that the consumers who bought in that different price range in the different market would have purchased the patentee's products if there had been no infringement. So the quick answer is it's going to require the same market, and that's usually indicated by price comparison. Thomas,
I think that's absolutely right. If the infringement did not deprive the patent owner of a sale that it would have made, then there is no lost profit. And that would apply in the patent assertion entity context as well. In both cases, the patent owner is certainly entitled to a royalty. It's lost royalty or a reasonable royalty, but it would not have suffered a lost profit as such.
I think I'm going to have to leave here, Professor, but I know our audience is in very good hands, and thank you for allowing me to exit a little early.
Thank you for joining us, Judge Rader, and I wish you a speedy recovery.
Yes, me too. Right now, I'm not feeling well. Thank you very much. Bye-bye.
Bye.
Thank you. Thank you.
So I'm going to move on to reasonable royalties. And so again, in the context of the Patent Act, Section 284 specifically refers to reasonable royalties. Upon finding for the claimant, the court shall award the claimant damages adequate for the infringement, but in no event less than a reasonable royalty. And empirically, reasonable royalties are the most common form of monetary compensation for patent infringement in the United States. Well over half of the cases result in reasonable royalties. Lost profits would be somewhere in maybe the 20 to 30% range at the most. And in awarding lost profits, or excuse me, in awarding reasonable royalties, courts and litigants will often consider at least some of the 15 factors set forth in the Georgia-Pacific case from the 1970s. So these are often referred to as the Georgia-Pacific factors. And the last of the 15, factor number 15, is arguably the unifying principle behind the factors in their entirety. That's the factor that asks the trier of fact to estimate the royalty a willing licensor and willing licensee would have agreed to from a date just prior to the infringement, knowing the patent in suit to be valid and infringed. So in some sense, we're trying to construct this hypothetical royalty. Now, critics of the Georgia-Pacific factors will often note with some justice that the factors can be rather unpredictable in their application. They can be to some degree manipulable by party experts. We often wind up with very different estimates from the two different sides experts on what the appropriate reasonable royalty should be upon application of the Georgia-Pacific factors, and also can lead to jury verdicts, which are difficult to review on appeal, since most patent infringement cases in the US these days are jury cases. That certainly is a point of difference from everywhere else in the world. That said, litigants and courts still consider the Georgia-Pacific factors. So for good or for ill, this is what does happen. And fortunately, though, there often are only a smaller number of considerations which to some degree span various combinations of the Georgia-Pacific factors that are of value in constructing the hypothetical bargain. So specifically, factor 2 tells us to consider comparable licenses. Factors 8, 9, 10, and 11 in various ways, articulating various emphases, tell us to consider the value of the patented technology to the defendant and to others. And so in this regard, the extent to which the defendant actually uses the technology, the extent to which the technology enables the defendant to reduce its costs or increase its profits, the advantages over the infringing, over the patented technology, over non-infringing alternatives, all of that plays into factors 8, 9, 10, and 11. And then factor 13, apportionment. That's important because we want to know the portion of the profit earned by the defendant or the benefit enjoyed by the defendant that is attributable to the patented invention as opposed to other factors, other features. I will note just in passing, I don't want to spend much of our time today talking about FRAND cases, but some of these factors sometimes are relevant in the FRAND context as well. Courts sometimes use a modified version of the Georgia-Pacific factors. So far, however, the Federal Circuit has not explicitly endorsed the use of some modified version of the Georgia-Pacific factors in FRAND cases. It is done, and it may be the correct thing to do, but we're still awaiting further clarification from the Federal Circuit on that particular issue. Also, I will note that some U.S. district courts, like some courts in other countries, have also on occasion used the so-called top-down methodology to determine FRAND royalties. That would involve trying to determine the aggregate royalty burden that is attributable to a particular standard as applied to a particular type of product, and then try to figure out somehow or another what portion of that aggregate royalty burden is owed to the patent owner. Sometimes courts in the US and elsewhere will use top-down as a check on the use of comparables or the other way around. Anyway, for our purposes today, I will just note that judicially determined FRAND royalties are still something of a work in progress in the United States. Anyway, going back to reasonable royalties, I mentioned comparables, and it is fair to say that judges and juries often find comparables to be the most relevant, most market-based evidence of patent value. Although at the same time, patentees are often vulnerable to challenges that their proposed comparables are not in fact really all that comparable to the hypothetical license for the patent in suit. I will say that judges and litigants often like comparables because there's an analogy that they can readily grasp. And when you're buying a house, you want to know what the other houses on the block have sold for. And whether that's a good analogy in the patent context or not, it is one that I have heard on multiple occasions. People can see the parallels. So for that reason, among others, comparables are often considered to be the most significant evidence used in determining a reasonable royalty. The difficulty, however, lies in the fact that often there may be no other license out there that we can use as a comparable that is completely on all fours with this hypothetical license for the patented technology. Often you have one patent, maybe a couple of patents in suit in a given case, and maybe the comparable license that you are considering is for a portfolio. That's a fairly common situation. And so unless sufficient care, unless sufficient care is taken to try to tease out the importance of the individual patent in suit in the context of this larger portfolio, there may be some vulnerability in terms of having that comparable used, in terms of having it be considered a reliable sort of indicator of what a hypothetical royalty would be for the patent in suit. So we saw this just very recently, just a few weeks ago, in the Federal Circuit's decision in Apple versus Wyland. So if you want to see some analysis of that, I had a discussion of that on my blog just a couple of weeks ago. Probably the leading Federal Circuit case on this topic in recent years, however, is Chief Judge Michel's decision in Lucent versus Gateway. Also, on occasion, courts may consider a license entered into in settlement of litigation as a comparable. Traditionally, that was not done, but there is some authority for that as well. The Federal Circuit's 2017 decision in Prism versus Sprint Spectrum basically stands for the proposition that under appropriate circumstances, a settlement license itself can be comparable. We have to examine the totality of the circumstances and see how closely comparable the settlement license is to a license for the patent in suit. A reasonable royalty award will often take the form of a so-called running royalty, meaning that we take a rate and we multiply it by a base. And so in cases involving complex products, meaning products that may embody multiple patented technologies, the question often arises whether the base should be the revenue earned from sales of an entire end product or some smaller unit. And so sometimes, as in the Lucent decision I just referred to, the Federal Circuit has suggested that it doesn't really matter all that much because, after all, multiplication is commutative. You can multiply a small rate by a large base or a large rate by a small base, and you get the same number. But maybe that's not the right way to think about it, particularly in the US context where we are often dealing with juries. And so more frequently, the Federal Circuit has stated that unless the patent in suit drives the demand for the entire product, the royalty base should be the smallest saleable patent practicing unit. Often you'll see the acronym SSPPU for that smallest saleable unit. That was the holding, for example, in laser dynamics versus quantum computer. And one of the principal rationales for the SSPPU rule is this concern about otherwise misleading the jury. If the jury hears a gigantic number as the royalty base, it may be inclined to award a disproportionately high royalty in comparison with the actual value of the technology. Indeed, sometimes the appropriate royalty base may be even smaller than the SSPPU, or at least further care must be taken to further tease out the value of the individual patented technology if the SSPPU itself embodies multiple technologies. That was the Federal Circuit's holding in Vernetics versus Cisco, where the court stated that the SSPPU is simply a step toward meeting the requirement of apportionment, where the SSPPU is in fact a multi-component product combining several non-infringing features with no relation to the patented feature. The patentee must do more to estimate what portion of the value of that product is attributable to the patented technology. So we have the general rule, use the SSPPU, or perhaps even something smaller than that, except when those rules don't apply. And this is where it does get somewhat difficult to advise a client what the actual state of the law in the United States is. So there is also a body of law that sometimes seems to point in the other direction. For example, Erickson versus D-Link, that was a case involving some FRAND committed standard essential patents. But in the course of that opinion, the Federal Circuit stated that it was permissible to allow an expert to testify about certain comparable licenses that used the entire value of the licensed products as a royalty base, as long as the expert explains to the jury the need to discount reliance on a given license to account only for the value attributed to the licensed technology. And the court gives a cautionary instruction if requested. And the logic there is that comparables, because they are sometimes good evidence of how the market values of technology, we don't want to throw those out simply because they happen to make use of the end product as the royalty base. In somewhat the same vein, this Federal Circuit decision from 2015, Ciro versus Cisco, this was in a bench trial, so some of these concerns about potentially misleading a jury may not be applicable here. Anyway, in this case, the court stated that although the district court may still need to adjust the negotiated royalty rates to account for other factors, it did not err in valuing the asserted patent with reference to end product licensing negotiations, contemplating a royalty of between 90 cents and $1.90 per end unit. So if that's what the parties themselves were assuming would be the appropriate royalty base during the course of their actual negotiations, maybe it is appropriate then to use the end product as the royalty base in crafting a reasonable royalty. At least in a bench trial, there's less concern perhaps about misuse. And one other case I will mention in this vein, the Federal Circuit's 2018 decision in Exmark versus Briggs and Stratton, where the patent actually claimed a lawnmower having improved flow control baffles. And so in that case, the court said it was appropriate to use the entire product as the royalty base, even though the inventive feature was just the baffle, but because the claim itself covered the entire product. So that might actually encourage a little bit of gamesmanship in terms of drafting claims to cover entire products, even though the royalty, the inventive feature may be a relatively small portion of the entire product. And I'll just leave this slide. I'm hoping that all of the participants will have access to these slides after the presentation, but there have been some more creative types of methodologies used in the United States in recent years, sometimes successfully, sometimes not. And without going into detail about how all of them might apply, I will just note that sometimes litigants have employed techniques from marketing, like conjoint analysis or the Nash bargaining framework, citation analysis, hedonic regression, which we saw in the VLSI versus Intel decision last year, which I believe is now pending on appeal before the Supreme Court. So there are some resources there for anybody who would like to see a little bit more extended discussion of what these techniques are, how they are employed in litigation, and the circumstances in which courts may or may not choose to accept them. All right, I want to say a little bit about extraterritorial damages as well. This is maybe a bit of an esoteric topic, but I think it's going to be a very important topic going forward, and it is the subject of a fairly recent US Supreme Court decision. So here's the basic fact pattern. Suppose that A owns a US patent on a product, and A makes patented products in the United States, sells some of them in the United States, sell some of them in other countries, such as Canada, where let's assume there is no corresponding patent. B infringes A's US patent by making the patented product in the United States in violation of Section 271A. B then takes some of the patented products it made in the United States, takes them to Canada, sells them in Canada. So A argues in this US litigation that B's unlawful manufacture in the US caused A to lose 100 sales in Canada, from which it would have earned $1 million in profits. So the question is, can A recover the $1 million in lost profit damages suffered in Canada against B, since the initial act of infringement occurred in the United States? Doctrinally, the answer to this question is still uncertain, though for reasons I discussed in a recent article, I think that the US Supreme Court's recent decision in Western GECO versus ION suggests a qualified yes to that question, and I'll explain why. So in Western GECO itself, the patentee used its patented system to perform surveys of the ocean floor for its customers on the high seas outside the jurisdiction of the United States. ION made in the United States components used for performing the patented system. It then supplied those components to customers outside the United States, who in turn combined the components and performed the patented system on the high seas in competition with Western GECO. So Western GECO cannot sue ION's customers because the customers are acting outside the United States. They're acting somewhere where there would be no patent in force, in international waters. But what they can do, what Western GECO can do, is sue ION under Section 271 F2 of the Patent Act. Somewhat obscure provision, but it reads as follows. Whoever without authority supplies in or from the United States any component of a patented invention that is not a staple article of commerce, knowing that the component is so made and intending that it will be combined outside the United States in a manner that would infringe the patent if the combination occurred within the United States, shall be liable as an infringer. So assuming that ION has violated this provision and that one or more of the patents in suit is valid, can Western GECO recover the profits it would have earned on contracts that it would have entered into to perform the patented system on the high seas? Is this just a standard lost profits case, or is there something different by virtue of the fact that the customers combining the components and using them are doing so extraterritorially? Well, to cut the analysis short, to get to the point, the Supreme Court in the Western GECO case sides with Western GECO, stating that the conduct that Section 271 F2 regulates, that is to say its focus, is the domestic act of supplying in or from the United States, and thus that lost profit damages that were awarded to Western GECO were a permissible domestic application of Section 284. The court does not reach the question of whether the same outcome would be appropriate in more common situations. 271F doesn't really come up all that frequently, a handful of cases every year involving that sort of fact pattern. The much more common fact pattern would be the one in my hypothetical involving 271A. Anyway, the Supreme Court doesn't reach out and address that sort of issue. So doctrinally, it remains somewhat uncertain what the correct answer is. Is in the hypothetical, in the more common type of situation, is the US patentee entitled to recover its lost profits on sales the US patentee would have made in Canada, but for the predicate act of infringement in the United States? Or is that an impermissible extraterritorial application of US law? Anyway, in the article I had on the preceding slide, I argue that the answer is yes, the patent owner should be able to recover its lost profit because the US court simply would be providing a remedy for the US infringement and is not extending US law extraterritorially. More generally, and consistent with the basic but-for principle of cases like right height and grain processing, I argue that US courts should award the US patentee damages for harms that are caused, in fact, by a predicate act of US infringement. There are limitations on the cause and fact principle, just general limitations imposed by tort law generally, where the causal connection between the US infringement and the foreign loss is too remote, then the proximate cause doctrine should curtail recovery. You could imagine a situation, for example, where there's some initial act of infringement in the United States that stimulates a foreign buyer to commission the making of certain products in another country. There's some cause and fact connection between the US infringement and the foreign conduct, but probably that would be too remote, indirect, unforeseeable, and would be cut off under the proximate cause doctrine. Similarly, if there is parallel litigation in the US and another country, then I would expect whichever country decides the litigation second to apply what is called the single recovery rule. It's a fairly general principle of law found not only in the US, but in other countries as well, to ensure that the patentee is not compensated twice for the same loss. So in terms of my hypothetical, there's an initial act of infringement in the United States that causes the patent owner to lose certain profits on certain sales it would have made in Canada if the US litigation results in an award of lost profits for the lost Canadian sales. And if there is parallel litigation involving a corresponding patent in Canada, I would expect the Canadian court to take the earlier US judgment into account and not to award effectively a double recovery for the same loss. There actually is some Canadian case law addressing that sort of situation. So I'm fairly confident that Canadian courts and courts in other countries would act in an appropriate fashion in this circumstance. Anyway, so far though, there has been no Federal Circuit case law since Western GECO addressing these issues. So we're still kind of awaiting further clarity from the appellate court. But there are some district court decisions which are consistent with the analysis I have set forth here. And I will also note that to the extent there is case law in other countries that I have been able to find, there's not a lot, but a little bit of case law, some limited case law in Canada and Japan is consistent with the analysis I am proposing here. And also this would be consistent with US practice in copyright cases, where for over a century, courts have basically allowed the copyright owner to recover monetary compensation that is caused for harms that are caused outside the United States, but which stem from some initial predicate act of copyright infringement in the United States. So if to the extent the copyright cases have been correctly decided, the patent case law seems to me should be consistent with that. Not everyone agrees with this, so for a cogent argument that everything I've just told you is wrong and that Western GECO should be applied more narrowly, I would recommend Professor Holbrook's article in the Columbia Journal of Law and the Arts. All right, it looks like we have at least 10 minutes to go. So Roya, should I just continue or do you want to pause for questions? I'm happy to continue on and talk about enhanced damages and disgorgement.
I'm tempted to just keep on going.
Keep on going? Okay, fine.
Yeah, and then if people still have time, we can add on Q&A, even though there are already nearly 10 questions out there, but it's just so interesting to listen to you.
Okay. All right, and I'm happy to take any questions now if you want to pause now, but otherwise I'll just move ahead and talk about enhanced damage.
Let's move ahead and maybe we just go a bit over time.
All right, so I do want to say a little bit about two more topics, enhanced damages and awards of the infringer's profits. So again, going back to section 284 of the US Patent Act, the last sentence states, highlighted here, the court may increase the damages up to 3 times the amount found or assessed. And that's all it says on the topic of enhanced damages. The statute specifies no criteria for the awarding of enhanced damages, but historically, traditionally, courts have interpreted this provision and its predecessors as authorizing awards of up to treble damages for willful infringement. That is said to affect a punitive and or deterrent purpose in appropriate cases. So kind of similar to the rationale for punitive damages in tort cases in the United States. If there is a finding of willful infringement, and a court decides to enhance damages or is considering whether to enhance damages, then traditionally various factors have been relevant in determining the size of the enhancement. It is not an automatic trebling as we have, for example, in US antitrust law. This is discretionary. The court may enhance the damages up to 3 times. So among the factors that would be taken into account would be the following: deliberate copying by the defendant, whether the infringer, when he knew of the other's patent protection, investigated the scope of the patent and formed a good faith belief that it was invalid or not infringed, the behavior of the defendant as a party to the litigation, the defendant's size and financial condition. We often see that being a relevant factor in punitive damages case law, the closeness of the case, the duration of the misconduct, Was there any remedial action by the defendant's motivation for the harm, and whether the defendant attempted to conceal its misconduct. These factors articulated in their entirety in the Federal Circuit's 1992 decision, Reed versus Portek. So anyway, over time, the Federal Circuit had decided several cases effectively limiting the availability of enhanced damages in various respects. Most importantly, by requiring proof by clear and convincing evidence that the infringer acted despite an objectively high likelihood that its actions constituted infringement of a valid patent, and regardless of the infringer's state of mind. So only if you got past this objective showing would you then consider the infringer's state of mind, whether the infringer subjectively knew or should have known that what it's doing was wrong. Anyway, the Supreme Court overruled this line of cases 6 years ago in Halo versus Pulse. So in the course of this opinion, the court took the historic approach. The assumption is that Congress, in enacting these various provisions over the years, did so against the existing backdrop of judicial practice dating all the way back to the 19th century. And so the opinion by Chief Justice Roberts states that the sort of conduct warranting enhanced damages has been variously described in our cases as willful, wanton, malicious, bad faith, deliberate, consciously wrongful, flagrant, or indeed characteristic of a pirate. And so the trier of fact should consider whether that describes the defendant's conduct. Specifically, what was the defendant's state of mind at the time of the misconduct? And so on the basis of this analysis, and after the fact reasonable, though unsuccessful, defense doesn't necessarily immunize you from enhanced damages, as it would have under the Federal Circuit's preceding case law. Moreover, the court says that the normal preponderance of evidence standard applies. There is no heightened, clear, and convincing evidence standard. So the trier of fact would determine whether the defendant's infringement was willful under the preponderance standard. And if so, then the judge would employ the judge's discretion to determine whether to enhance damages, and if so, by how much. So that's where we are at present on that issue. And not surprisingly, awards of enhanced damages have increased since Halo versus Pulse, although they're still awarded in only a minority of cases. So we're still not talking about a huge number of cases. There's usually going to be some empirical analysis every year or so, tallying up the number of cases. There was one on IP Watchdog last year that says that in the 5 years since Halo, there were 15 judgments for enhanced damages in 2017 and 2018, 13 in 2019. So we're seeing numbers that are certainly higher than what we had before, although it's certainly not every case either, but a higher number as one would expect. And also the lower courts, the district courts, continue to apply these Reed versus Portek factors to determine whether or not the damages actually should be enhanced based on a finding of willfulness, and if so, in what amount. The Reed versus Portek factors remain relevant. There are a few outstanding issues that the Federal Circuit has not yet at least explicitly decided. The lower courts have expressed different views on these. For example, whether knowledge of the patent in suit is a necessary requirement for a damages enhancement, or if some lesser state of mind, such as recklessness or willful blindness, can suffice. I would say that the Federal Circuit case law has kind of pointed in the opposite direction, that knowledge means actual knowledge, but it's not 100% clear how that issue will ultimately be resolved. Also, sometimes the issue arises whether we should focus explicitly and exclusively on pre-litigation conduct by the defendant, but what if the defendant continues to infringe allegedly, after the filing of the complaint. Could that provide a basis for a finding of willful infringement? Based on my review of the cases, I would say that most of the lower courts have concluded that post-filing conduct can serve as a basis for a finding of willful infringement. But some courts, particularly in the District of Delaware, will require the patent owner to file an amended complaint, since you can't allege anything about post-filing conduct when you file your initial complaint. All right, Roy, should I move on to defendant's profits or stop?
Yeah, sure.
Okay,
Yes,
all
yes.
right. So I'll say a few words about defendant's profits, and then I will stop. And if we have time, I'll be happy to take questions. So this is a remedy that is available in the United States for design patents, but not for utility patents. And that's different from much of the rest of the world, where an award of the infringer's profits has long been an alternative avenue for relief in both design and utility patent cases. Also, many countries don't call these things design patents. You might call them design rights or industrial design rights, but in the US, these types of rights are placed within the patent statute. It's a type of patent for a novel design. Anyway, the disgorgement, as I said, is a common remedy elsewhere. And it was actually a common remedy for the infringement of utility patents in the United States until 1946, when Congress eliminated it for utility patent infringement on the theory that patent cases, utility patent cases that involved a request for disgorgement of the infringer's profits were simply becoming too complex, costly, time-consuming, and just wasn't worth it. Reasonable royalties were viewed as an acceptable substitute. But curiously, though, we retained the disgorgement remedy for design patent infringement, where it has been governed since 1887 by a standalone statute, Section 289. And the purpose of this 1887 statute, as subsequently amended, was to make it easier for owners of design patents to recover monetary relief by overturning a couple of Supreme Court decisions from the early 1880s that had precluded the owner of a carpet design from recovering any lost profits where the owner was unable to prove the portion of its damages attributable to the defendant's use of the infringing design. So because of the difficulty of proving lost profits, Congress made it easier for design patent owners to recover the infringer's profits. And specifically, the current version of the statute, Section 289, reads as follows. Whoever, during the term of a patent for a design without license of the owner, applies the patented design or sells or exposes for sale any article of manufacture to which such design has been applied, shall be liable to the owner to the extent of his total profit, but not less than $250. I believe they've never indexed the $250 for inflation. I think that was the original number from 1887. So that's not terribly meaningful, but total profit, the part that I put in boldface there, that's kind of significant. The design patent owner can recover the infringer's total profit, at least on something, the article of manufacture. Nothing in the section shall prevent, lessen, or impeach any other remedy which an owner of an infringed patent has under the provisions of this title, but he shall not recover twice the profit made from the infringement. So none of this seemed all that terribly important for a long time, because in design patent litigation, damages were typically fairly small, but that has begun to change. So in 2015, in one of the cases between Apple and Samsung, the Federal Circuit affirmed the district court's reading of the statute as requiring Samsung, which had been found liable for infringing 3 design patents, to disgorge its total profit, amounting to $399 million, from sales of devices that were found to be infringing. So these were the design patents at issue. So Samsung was found to infringe these 3 design patents, and therefore had to disgorge its entire profit, its total profit on sales of infringing phones, even though surely a lot of that profit would be attributable to features other than the design. Now, there's all the functional features among other things. Anyway, so is that the correct interpretation of the statute, or does total profit not necessarily relate to the entire profit on the sale of a complex end product? Well, in 2016, the US Supreme Court weighed in Samsung versus Apple. The Supreme Court reversed, but held the following. Arriving at a damages award under Section 289 involves two steps. First, identify the article of manufacture to which the infringed design has been applied. It doesn't necessarily correspond to the entire end product. It might, but it doesn't automatically. So figure out the relevant article of manufacture. And then second, calculate the total profit made on that article of manufacture. And the court, a little bit unhelpfully perhaps, says we decline to lay out a test for the first step. So leave it to the lower courts to determine what the appropriate criteria are for defining the article of manufacture. On remand, in this case, the district court applied a 4-factor test that had been suggested by the United States Solicitor General in the case before the Supreme Court. These 4 factors: the scope of the design, the relevant prominence of the design, whether the design is conceptually distinct from the product as a whole, and for the physical relationship between the patented design and the rest of the product. In other words, does the design pertain to a component that is physically separable? Is it embodied in a component that is manufactured or sold separately? So applying that test on remand, the jury apparently reached the conclusion that indeed the entire Samsung phone was the relevant article of manufacture. And in fact, it rendered an even larger award of total profits, $539 million. So since that time, several other district court decisions have applied or have instructed the jury to consider the 4-factor test. And in all or most of these cases, the trier of fact has concluded that the relevant article of manufacture was the entire device, and so the defendant is liable for the total profit earned on sales of the entire device. However, there is one recent district court decision in which the court concluded that because historically this sort of award in a patent case would have been considered a quote unquote equitable remedy, there actually is no right to a jury trial. This should be an issue for the judge alone to decide. So anyway, the Federal Circuit has yet to weigh in on any of these issues. Presumably someday the Federal Circuit, maybe even the Supreme Court, will provide us some further guidance on whether the 4-factor test is the correct test for defining the article of manufacture, whether this is a jury issue or a judge-only issue, and how we calculate the total profit on the relevant article of manufacture if it is not the entire end product. So I will stop there, and if we have some time, I'll be happy to take some questions for a few more minutes.
Yeah, no, thank you very much for this excellent presentation, very informative presentation. God, where are the questions? Jesus, there's so many questions. Where's the level of burden of proof required for lost profits beyond reasonable doubt? Okay, let's see. I haven't read the questions in advance. So the first question is from Richard, who's asking, where's the level of burden of proof required for lost profits? For example, beyond reasonable doubt.
Yeah, so generally speaking, the patent owner would have the burden of coming forward with evidence and the ultimate burden of proof as to damages generally. And on the 4 factors, the Panduit factors, specifically the absence of non-infringing alternatives, I would say that the case law is a little bit confusing, but the more recent Federal Circuit opinions seem to be fairly clear in stating that the patent owner has the burden of proving an absence of non-infringing alternatives. It might be more rational to allocate that burden to the defendant of coming forward with evidence of the presence of non-infringing alternatives. The grain processing decision actually seemed to allocate the decision to the defendant, but the more recent cases seem to allocate it to the plaintiff. Whether that is a good rule or not, I think that is an accurate statement of where we are at present.
Okay, then the next question is, inflation is a current macroeconomic concern for many. I agree, including potential patent litigants. Is it fit? If it fits into your discussion, are there any unique considerations for inflation in damage assessments?
Oh, all right. Yeah.
Curious
So,
about damages looking backward when inflation is relatively known and forward when it isn't. Thank you.
yeah. So, well, a couple of things. So, in the U.S., prejudgment interest is routinely awarded in patent cases. That is not always the case in other countries. Different countries have different rules on this. In the US, prejudgment interest is generally going to be awarded. The district court has a considerable amount of discretion in determining the appropriate interest rate and whether to compound the interest, as an economist would say you should, because otherwise you are actually not making the patent owner as well off as it would have been absent the infringement. But anyway, prejudgment interest would be one way of taking into account the time value of money, and the interest rate, of course, may be higher if we are going through a period of high inflation. Also, to compensate for losses that are suffered between the date of the filing of the complaint and the entry of judgment, courts will often award so-called supplemental damages, which would be basically a continuation of a reasonable royalty up through the date of the verdict. So again, that's a way of trying to take that into account. In terms of future damages, if a court denies an injunction, as we do in some cases in the United States under the eBay factors, and awards an ongoing royalty, I haven't actually seen any discussion of how inflation might interact with that, but that's an interesting idea that maybe the ongoing royalty should take into account the probability of future inflation to make sure that the patent owner is being adequately compensated. So anyway, I have to think about that one some more. I just haven't seen that come up yet.
And there's another question from Lillian. She's asking, does this calculation on lost profits change if there are multiple patents in suit?
Yeah, so the Mentor Graphics case, I think, would be an illustration of a situation where the product that the parties are selling in competition with one another is a multi-component product that may embody multiple features, multiple patented technologies. So the patent owner would be able to recover lost profits in a case like that only if it can demonstrate that absent the infringement of the patent in suit, the patent owner would have made some sale the defendant wound up making. That's going to be perhaps a fairly uncommon situation, because if we are dealing with a multi-component product, there may be other alternatives that the defendant could have used that might have raised its costs to some degree, but it still could have taken sales away from the patent owner. So everything basically will hinge on what the facts are, what the evidence can show. There's a very interesting article, I probably should have cited it in the slides, but by a Stanford law student, Jason Reinecke, who goes through many different variations of Mentor Graphics. For example, what if each party owns a patent that the other one must use to sell its product? And I think he's correct in concluding that in that case, neither party can show a lost profit. What they would have to settle for would be a reasonable royalty. But anyway, I would recommend his article for further analysis of the many different variations on the Mentor Graphics theme.
Last question, which is from someone anonymous, asking whether Professor Cotter's single recovery rule conflicts with comity. And the person wonders if this is a theme surrounding the front litigation in SEPS.
Yeah, I don't think it conflicts with comity. What I'm suggesting here is what courts should do and what I would expect them to do. So based on my research, it is not only courts in the United States, but courts in other common law countries, and indeed courts in other civil law countries, applying principles sometimes dating back to ancient Roman law. Most jurisdictions apply some version of a single recovery rule. Now, there's no binding constraint that compels them to do that. The United States cannot compel, Canada to apply the single recovery principle. No, so there is some risk that a court in a country could ignore it and award duplicative damages. I think that risk is relatively low, however, given the longstanding tradition of applying some version of a single recovery principle. But I will admit that I'm kind of going on faith there that courts will act appropriately. In the FRAND context, I mean, this issue, to my knowledge, hasn't really come up there. Usually, in the cases in which courts in the US or elsewhere have awarded global FRAND royalties, typically they do that, based on some analysis of what the royalties should be on a country by country basis. So that would eliminate the need for duplication to the extent that the damages are being awarded in the place of manufacture or the place of distribution, but we're not awarding double damages for the same patent.
With all of that being said, we have nearly 10 comments which go along the lines, excellent presentation. Thank you for an excellent presentation. What an amazing, excellent presentation, and so on. I'm not going to say that 10 times. I really must agree for the 11th time. This was an excellent presentation, and we're really, really happy that you gave us your time and your thoughts and ideas to share your insights on damage calculations. Make it if 12. Bravo from Kelly.
Well, thank you very much.
Really happy with your presentation. Oh yeah, and the conference I talked about is here, the 7th IP and Competition Forum, June 21, 22 in Munich, in the House for Literature, right in the city center, where we'll be talking 5G licensing and valuation. We have already quite some nice participation from companies and judges. I didn't have the time yet to reach out to scholars. If you're interested in getting involved, send us an email, info@oxfirst.com. Look at our website. We'd love to have your views, ideas, and suggestions. Yeah, and with all of that being said, thank you for lasting with us. If so, we ran over time as usual. We have our next webinar coming up with the Weizmann Institute in Israel, talking about the role of patent value in technology transfer and tech commercialization, and learning how the Weizmann Institute is dealing with patent value and tech transfer. I think it's sometime in a couple of weeks from now. So thank you very, very, very much. Have a lovely afternoon. We plan to make the PowerPoint available and put the video up also as soon as we can. All right. Thank you again very, very much. There were another 2 comments saying excellent presentation, Tom.
Thank you. All right. Goodbye, everybody.
Bye-bye. Thank you.